Good evening, everyone. Good evening, everyone. Thank you. Make sure we're still awake on this fine evening. My name is Ebony Nelson, and I have the honor and pleasure of serving as Dean of this great law school. On behalf of the University of Connecticut School of Law staff, faculty, students, and alumni, I welcome you to our inaugural Jurist-in-Residence program lecture. I extend a special welcome to the esteemed members of the judiciary joining us this evening, especially the Honorable Victor A. Bolden, who graciously agreed to serve as our inaugural Jurist-in-Residence. UConn School of Law is extremely proud that a significant part of our legacy is the strong, long-lasting relationship we have shared with the judiciary. We would not be the outstanding, nationally and globally recognized law school that we are today without the assistance and support not only of our graduates, but also graduates of other law schools who have ascended to the bench, and for that, we thank you all. As the state's only public flagship law school, we consider it our honor and responsibility to partner with the judiciary to advance justice here in Connecticut and beyond, and to educate and inspire future members of the bench. We are grateful for the many opportunities that have allowed our faculty, staff, and students to engage with members of the judiciary, and our new Jurist-in-Residence program has already proven to be an invaluable opportunity for our law school community and others to come together to learn and benefit from the wisdom and expertise of our esteemed jurists. I extend a special note of thanks to our Associate Dean for Faculty Development and Intellectual Life, Ann Daly, who has been instrumental in organizing Judge Bolden's visit this week. I also would like to thank our events, ITS, communications, Dean's office, and catering staff who helped to plan and facilitate this week's events. At this time, it gives me great pleasure to introduce this evening's lecturer, the Honorable Victor A. Bolden, United States District Judge for the District of Connecticut. Judge Bolden is a native of New York City who earned his AB from Columbia University and his JD from Harvard Law School. His legal career began at the ACLU Foundation's National Legal Department as a fellow, then staff attorney for 4 years. He then joined the NAACP Legal Defense and Educational Fund as assistant counsel for 6 years, followed by private practice at Wiggin & Dana in New Haven from 2000 to 2005. After returning to the NAACP Legal Defense and Education Fund as general counsel from 2005 to 2009, Judge Bolden served as the City of New Haven's Corporation Counsel until his appointment to the District Court by President Barack Obama in 2014. This week, Judge Bolden visited Dean Daly's constitutional law class, during which he advised students, and I quote, "Figure out what you want to do, discover your passion, and do what makes you happy." I think that's pretty good advice for all of us. Last night, over dinner with our students and faculty and staff, he shared instructive strategies for engaging in effective advocacy. This time he has shared with us has truly been educational and inspiring, and I have no doubt that tonight's lecture on proof, the rule of law's most essential element will be as well. Judge Bolden, thank you for taking time out of your very busy schedule to be with us this week. We are deeply honored that you are UConn Law's inaugural Jurist-in-Residence, and we look forward to your lecture. Welcome and thank you.
Thank you very much, Dean Nelson, and I also want to offer thanks to Dean Daly, who has been instrumental in working with me to make this visit possible. I also want to give thanks to all the other judges who've attended this lecture, and I really appreciate it, particularly my colleagues in the District of Connecticut. My schedule has been crazy, and I've been missing a lot of district meetings and events And the fact that they're actually coming here is a real testament to how wonderful they are and the great colleagues that I have to work with. These last few years have been rather tumultuous. In the midst of a global pandemic which resulted in more than 100 million cases here in the United States and over 1 million deaths, the nation also has literally played witness to the death of George Floyd on May 25th of 2020, an attack on the U.S. Capitol on January the 6th of 2021, and experienced landmark rulings from the U.S. Supreme Court in the challenging issues of guns, abortion, and race. All of this in less than half a decade. At least two of these events, the death of George Floyd and the Supreme Court's decision in Dobbs, have tested the faith of the American public in the rule of law. That is, the notion that this nation is governed by orderly processes first promulgated in the Constitution and further defined by other bodies of law, and that these laws are faithfully and appropriately executed and followed by those given authority to govern and those who are to be governed. And a third, the January 6th attack on the Capitol directly threatened the rule of law itself. As the saying goes, or at least a paraphrased version of that saying goes, these are times that try one's soul. The rule of law and belief in it in America seems to be under constant attack, whether it is the use of force to challenge election results or growing dissatisfaction with the legal process or lawyers because of court rulings or legal filings. There is reason to worry about the country's ability to sustain a widespread belief in and commitment to the rule of law. Indeed, these are the times when people resort to William Butler Yeats's words from last century in the poem, The Second Coming, turning and turning in the widening gyre. The falcon cannot hear the falconer. Things fall apart, the center cannot hold. Mere anarchy is loosed upon the world. The blood-dimed time is loose and everywhere. The ceremony of innocence is drowned. The best lack all conviction, while the worst are full of passionate intensity. Later in the 20th century, during a similar time of seemingly unending challenge and deep and abiding despair, in 1967, the Reverend Dr. Martin Luther King Jr., just a year before his assassination, wrote his last book, Where Do We Go From Here? Chaos or Community. In that book, he confronted the quandary of a nation engaged with violence abroad and struggling to prevent social unrest at home. The nation's capacity to engage thoughtfully and productively through legal means or even engage in protest or discussions nonviolently was sorely tested then, as it very well may be now. As the title of his book suggested, Dr. King sought to provide a choice for a better tomorrow. He did not seek to simply lament the challenges of that day or any yesterday. Instead, he placed the challenges of the moment in context. Quote, "The line of progress is never straight. For a period, a movement may follow a straight line, and then it encounters obstacles and the path bends. It is like curving around a mountain when you are approaching a city. Often it feels as though you are moving backwards and you lose sight of your goal, but in fact you are moving ahead, and soon you will see the city again closer by." Tonight I want to offer a similar choice about the rule of law. I want to affirm what I believe, and in my view must be the rule of law's most essential element, proof. We live in a world now where what is not real, what is clearly quite fictional, can sometimes be passed off as the truth. And with modern technology, and in particular the rise of means of electronic communication, capable of creating and sending about just about any message to anyone and everybody in an effort to get them to believe something, some people have actually come to believe in things that are demonstrably false. And then the people who have accepted these demonstrably false things then occasionally do what people do when they hear something that comforts their own beliefs, that suggests that they are in on something that nobody else knows. They tell others in hopes that they too will believe it. So they are not alone. There's a building of a community of sorts, and then because someone somewhere said something, everyone else should believe it. In this world outside of the law, proof appears less important, and in some cases appears to be irrelevant. Instead, what matters is belief, and what we may be living in an age of belief. It is not necessarily belief as defined in the past as an actual belief in God or a specific religious affiliation, and it also is not necessarily a belief as measured by participation in traditional institution. It's not even a belief sometimes as measured by traditional participation in partisan politics. Instead, the age of belief may be a time where people have come to adopt beliefs for whatever reason, and once adopted, in many instances, believe it necessary to hold on to those beliefs rather fervently, despite any proof to the contrary. In other words, people seem increasingly to want to believe what they believe and do not care if there is evidence suggesting that they should believe something different. And having performed their belief, there's a tendency to hold on to it, even if new evidence emerges that requires adjustment or a total course correction. In short, consistent with the theory of confirmation bias, once people form their belief of how they wish to view something, they continue to hold on to those views. I and all of you, whatever we decide to believe or accept as truth in our private lives, are challenged to measure up to a different standard when it comes to the law. In the law, proof, not just proof we like, not just proof regardless of how irrelevant or baseless it is, but proof of a high enough quality and sufficient enough in quantity is what has been needed, is needed, and will forever be needed if we are to sustain the rule of law in this country and be one country indivisible with liberty and justice for all. Proof, therefore, is the most essential element to the rule of law. There are three main reasons. First, the American legal system is organized around principles of proof. Second, in the law, even what might be described as beliefs, legal theories and judicial philosophies, actually are another way of iterating the significance of proof in the American legal system. Third, and finally, American belief in the rule of law and our best hope for sustaining belief in the rule of law lies in proof that the American legal system works. It is not to have a belief that it works or to espouse a belief that it works, it is to have a system that actually works. So with the first point, perhaps without fully realizing it, the linchpin of American law is proof. Our legal system is organized around principles of proof, two basic principles, in fact, admissibility and sufficiency, or put another way, quantity and quality. There is an issue as to whether a particular piece of proof is admissible, so that's a threshold issue. So even if it is admissible, or more importantly, can be considered, the amount of evidence provided must be enough to satisfy a specific burden of proof. Another lay way of thinking about it, again, is quality and quantity. In order to be worthy of consideration, the evidence must be of a certain quality, and in order to prevail, there must be enough of it. The first standard, the admissibility or quality of evidence standard, is obviously governed by the federal rules of evidence or the relevant state law analog, and it helps guide us what constitutes evidence. So critically, proof in the legal context, proof to be relied on to sustain the rule of law, must go through a vetting process. Just because you have evidence of something does not mean you have evidence of something relevant to the legal case in hand. Or even if there is evidence that may be relevant, that the evidence may be proper to consider, may not be proper to consider given the legal issue at hand. In a particular issue, there might be something about that otherwise relevant evidence that may be distracting from the resolution of the ultimate issue. A concern that rather than decide what the finder of fact is supposed to decide, for the reasons it is supposed to decide it, that something else, this distracting evidence, may guide the decision-making process. This is the concern codified in Rule 403 of the Federal Rules of Evidence. The Federal Rules of Evidence have codified specific rules to address particular types of distracting evidence beyond 403. That is the purpose of Rule 404 about character evidence generally, and past criminal wrongdoing specifically, or even Rule 405, which addresses the permissible methods of introducing character evidence, or Rule 406 about evidence of a habit. It is even why a very specific rule, Rule 412, was adopted to govern evidence about a sexual crime victim's past sexual history. We do not want the finder of fact to be distracted by other things, even though vaguely relevant, when a decision has to be made about something far more significant. On the quality of evidence issue, there's also this concern about where did the proof come from? Just because someone somewhere said something does not make it evidence. Indeed, unless it fits within a fairly narrow, often although lengthy list of exceptions, that evidence will be considered hearsay. Likewise, even if testimony can come straight from a source, there's still a concern about whether if it's a lay witness, that there's personal knowledge about the evidence being offered, and if it's an expert witness, that the basis behind any evidence offered is sufficiently sound given that person's alleged area of expertise. Indeed, any offer of proof, whether from a live witness or an exhibit, must have a sufficient foundation before it can be worthy of consideration in deciding a matter. So what we consider proof in the legal world, what is necessary to uphold the rule of law, is far different from what people in their ordinary lives consider in terms of the quality of proof necessary to make a monumental decision. As I noted at the outset, the quality of the proof is not the only metric. The law also is concerned about the quantity of the evidence. To prevail in court, you must satisfy a burden of proof before you even get to the trial. Within the federal rules adopted for both civil and criminal cases, there are guideposts along the way about how quantum matters with respect to proof, and in some ways mirrors the obligation with respect to quality. Before trial in a civil case, there are two procedural hurdles to climb over, one codified in the motion to dismiss standard and the other in the summary judgment standard. Indeed, in recent years, the Supreme Court rulings in Iqbal and Twombly have highlighted this issue. And even before the civil lawsuit is filed, there's an increased expectation that your lawsuit has some evidentiary heft behind it. Likewise, with the summary judgment standard, after the discovery process is ended, you not only need to provide proof that there's a genuine issue of material fact in dispute, your proof has to be organized in specific ways and not disguised. In fact, it is routine for federal courts like mine to grant summary judgment in a case before trial in the absence about sufficient clarity of the proof giving rise to the dispute. In criminal cases, although treated differently from civil ones, there are also these procedural hurdles to climb before a trial. For a felony, before you can even charge the person with a crime in any federal court, you need the indictment from a grand jury. There must be evidence of probable cause that a crime has been committed and the person proposed to be charged committed the crime. There are circumstances where even if charged, if there's evidence that the proof was not gathered in a proper way, say it has been illegally seized, then the charge could be dismissed and the matter may never reach a jury. And just as with the civil system, even if you make it to a trial, if after presentation of the prosecutor's case there's not enough evidence for a jury to sustain a conviction, the case can be dismissed before it even gets to the jury. To illustrate that point, I like to use the following example, which just sort of helps distill this notion of what's different in the world we live in the world that we have to litigate in terms of what courts, is that if a prosecutor comes in the court and says, I believe the defendant is guilty, it doesn't mean anything unless there's proof sufficient to support it. In other words, I shouldn't let the case go to a jury. And that doesn't add anything. The judge says, the prosecutor says, no, judge, you don't understand. I really believe this defendant is guilty. Without proof, and not just proof, but enough proof that a jury could conclude that there is guilt beyond a reasonable doubt, it's not a case that should go to the jury. Then at trial, whether it's a civil case or criminal case, there's questions about what constitutes evidence for a jury's consideration, and even before trial, there might be motions to exclude evidence believed not proper for a host of reasons, and during trial, there might be objections about profit evidence. And just because evidence is admitted doesn't mean it can't be challenged. So proof isn't proof of everything. Proof may not be sufficient in some cases. Eyewitness testimony, there might be questions about lighting at the time, the person's distance from the event, or the quality of a person's eyesight. So finally, at the end of the trial, when all of the evidence is deemed proper, just having some evidence isn't enough. It's that quantity thing. The standard and the burden of proof. In the civil case, the preponderance of the evidence. In criminal, it's a reasonable doubt. And then we have that proof goes to a jury. They have to decide it. And the jury has to unanimously agree. Just dwelling that on the juror role. And even before we allow someone to be a juror to be able to consider proof, we want to make sure that that person can fairly serve. We want to make sure that there isn't something about this issue that may exclude that person. In picking a jury a few years ago, I had a prospective jury state that she followed a biblical view of justice and would have to view cases through the lens of those beliefs. In probing a little further, I have to admit, I couldn't figure out exactly how her views would affect how she would serve as a juror, so I ended up having to excuse her. Because I had no idea whether she would actually follow the law. But she had beliefs that she was concerned about that might conflict with her ability to see the evidence. I've also seen it in situations where, and it's happened more frequently, although I've also heard from colleagues, it's been a historic concern about trying drug cases and individuals, and particularly in the context of the opioid epidemic, individuals who either from personal experience or people they know, the experiences of some overdose or some addiction in the context of the family, listening to them in a sort of a more of an individual voir dire setting, and just watching how that experience has an impact on them. And you know that that's the kind of case they will not be able to serve. So even with this, my point being that the role of the jury in part of that process of evaluating proof, we're looking for individuals who can actually bring a sense of fairness to it, that they're not going to bring something else other than what is there to analyzing what they need to do. And all this is really just sort of showing us this is all we really know, just summarizing what we know, but it is to sort of illustrate that these burdens of proof and these evidentiary standards are at the heart of what we do on a day-to-day basis and the heart of our legal system. And it raises an interesting question that, given the significance of proof in this particular way, as I've talked about, does beliefs even matter, or should they matter? The answer, of course, is yes. But beliefs as expressed in legal theories or judicial philosophies are best understood as direct means for expressing what proof should matter, rather than an indication that proof does not matter, or that any specific legal theory or judicial philosophy should be a substitute for the significance of proof, or that any particular legal theory or judicial philosophy should matter more than proof. Indeed, as I will discuss in a moment, belief in proof should be viewed as part of a seamless whole, rather than disparate or even conflicting parts. And just as importantly, as I'll explain, you can view the various legal theories or judicial philosophies through the same lens as you do the burdens and standards with respect to proof. In essence, they address the quality and quantity of proof necessary. So I'll turn to it. Notions of justice, and particularly concepts within the system of justice, such as equal protection and due process, are beliefs, and the proofs of these beliefs and many others are enshrined in our founding documents, the Declaration of Independence and the Constitution, just as the various measures of proof are codified in other ways. There are also a variety of legal theories and philosophies which help explain these beliefs and how they should be put into effect in the American legal system. There are no shortage of legal theories and judicial philosophies, and I'm not going to try to discuss them all, but I do want to discuss a couple just as a way to illustrate my point. And to be clear, I understand that there are various ways to define all of these various terms, and that within legal academic circles, as in here, and even among judicial adherents of one judicial philosophy or legal theory or another, there are various definitions and significant differences and small nuances in approach. My interest is far more limited. I just want to have basic working definitions for illustrative purposes. I'll start with textualism. Under this theory, legal text should be interpreted based on the text's ordinary meaning. The focus is on the language in the text, not external sources. While touted as a belief, and it really is also could be described as a belief in a very specific kind of proof. From a quality standpoint, it is a notion that if I want to know how to interpret a provision of the U.S. Constitution or a statute, the text provides all of the proof that I need. For example, in Article 2, Section 1 of the Constitution requires that the office of the president be held by someone 35 years of age. From a textualist perspective, and practically probably most perspectives, this very clear language should mean only one thing. The person who becomes president must have a date of birth of at least 35 years of age before taking the oath of office. Under this perspective, it does not make sense to permit evidence that the office of president could be held by someone younger than 35, but otherwise possessing the maturity of someone who is at least 35 years of age. Put another way, the relevant proof of what this position means is contained in that plain language, and there's no need to permit other extrinsic evidence to interpret it. In this example, the text of the language provides both a check on the quality of the evidence considered permissible and the quantity necessary to sustain the relevant burden. In this case, there must be proof of that person being at least 35 years of age. The fact that the clear language of this constitutional provision defines what proof is needed doesn't resolve definitively what specific proof will satisfy the standard, but it clarifies who should hold office and what evidence will be required to prove it. And our willingness to accept whether someone is of sufficient age to be the president is an intrinsic part of why this interpretation makes sense. To be clear, the issue is not whether someone could make an argument for a different interpretation. The issue is instead is whether that interpretation could bring enough support for the American people to accept it as a viable legal principle. Originalism is another prominent legal theory, one in which some say, or should be, the dominant judicial philosophy. The focus in originalism is to the extent distinct from textualism, is that the meaning of a constitutional provision should be interpreted consistent with those who drafted the provision thought its meaning should be at that time. Of course, one of the most obvious examples of its most recent use is in the Supreme Court's 2022 decision in Dobbs v. Jackson Women's Health Organization. In Dobbs, as described by Justice Alito's majority opinion, the interpretation of the 14th Amendment's due process clause as it relates to the issue of abortion required a, quote, historical inquiry. As he wrote, quote, historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the due process clause, because the term liberty alone provides little guidance. Justice Alito then goes on to rely on legal treatises and other historical materials from that time period and discusses the treatment of abortion at common law and in the United States to conclude that, quote, a right to abortion is not deeply rooted in the nation's history and traditions. Significantly, for purposes of my analysis tonight, the most salient aspect of originalism is its reliance on proof, and then applying that proof to the topic at hand, the legality of a statutory provision severely limiting the right of women to obtain an abortion. Indeed, if you translated this analysis into terms consistent with the federal rules of evidence, the distillation of originalism amounts to Rule 401 analysis in terms of relevance. The only relevant evidence is proof from the time of the adoption of the 14th Amendment and how the law treated the subject of abortion at the particular time. All other evidence is not relevant in resolving this legal question, or to use another provision of the Federal Rules of Evidence, Rule 403, its probative value is outweighed by its prejudicial effect. In this case, the prejudicial effect comes from relying on anything other than what the framers of the 14th Amendment could have considered at the time. The reason behind this limitation of the relevant body of evidence is grounded in the basic principles underlying the Federal Rules of Evidence, whether evidence beyond this time period has a sufficient indicia of reliability. Similar to, but quite different from textualism or originalism, or other legal theories such as judicial restraint, a phrase most popularly coined by famed 19th century Harvard Law School professor James Bradley Thayer. He outlined it that federal judges should defer to the actions of Congress, and the president, and legislation or executive action should only be declared unconstitutional only in cases of very clear mistakes or beyond a reasonable doubt. The most prominent proponent of this judicial philosophy on the Supreme Court was likely Justice Felix Frankfurter, who revered Thayer's approach to the law and sought to apply it faithfully. In his dissent, Justice Frankfurter's dissent in Baker v. Carr, a decision known for limiting the scope of broadening the scope of the political question doctrine and permitting litigants and then courts to find legislative apportionments of certain magnitude to be unconstitutional, Frankfurter sort of laid out his theory about why it's important to be very clear that you don't go beyond the competence of the judiciary. Again, it's another way of thinking about it. If you think about it, it's another way of looking at proof. His concern about having proof beyond certain areas then undermines the indicia of the reliability for that proof. And of course, just like all legal theories, they boil down to this question of proof, what type of proof and how much proof is needed to find a statute or executive action unconstitutional. And of course, for just about every philosophy or theory, there is a competing one. And they see the quality and the quantity of proof differently. For example, in response to Justice Alito's originalism in Dobbs, there is the approach taken by the dissenting justices, Justice Stephen Breyer, Justice Sonia Sotomayor, and Justice Elena Kagan. In their view, quote, as a matter of constitutional method, the majority's commitment to replicate in 2022 every view about the meaning of liberty held in 1868 has precious little to recommend it. Our law in this constitutional sphere, as in most, has for decades upon decades proceeded differently. It's considered fundamental constitutional principles, the whole course of the nation's history and traditions, and the step-by-step evolution of the court's precedents. It is disciplined but not static. It relies on accumulated judgments, not the sentiments of one long-ago generation of men who themselves believed and drafted the Constitution to reflect that the world progresses. And by doing so, it includes those excluded from that olden conversation rather than perpetuating its bonds, end quote. And then they go on in dissent in Dobbs to say, quote, no liberty entry is present because and only because the law offered no protection to the woman's choice in the 19th century, but here's the rub. The law also did not then and would not for ages protect a wealth of other things, and they go on to articulate it. But for purposes of this lecture, what I really want to focus on is that while the majority in Dobbs does not see proof beyond any thought contemporaneous to the time of the adoption of the 14th Amendment's Due Process Clause, the dissent is saying that the quantum of evidence should extend far beyond that, even to the present time. Indeed, in raising questions about the limitations on the quantum of evidence, the dissent in Dobbs is also saying something about the quality of the evidence without permitting a broader scope of proof to resolve the issue. In that case, because the issue involves the health of women, there's something bizarre about limiting the relevant evidence to a time when women had no input, meaningful otherwise, into whether there was a right to an abortion in the 19th century. I say this not for purposes of rehashing the various perspectives, but to really recognize that this is another iteration of the significance of proof in the American legal system. And so now, having sort of discussed that, I do want to turn to the third and actually probably the most substantial reason for suggesting that the proof is the rule of law's most essential element. It's our own hunger and desire to have proof that our legal system works, a desire that's reflected both historically and in the present day. Even before the nation's founding, the struggle to forge this nation from its British roots entailed a struggle through proof. The most compelling example is actually in the Declaration of Independence itself. An extraordinary document by any measure, its power very well may lie in its specificity. It is not merely a general or even a theoretical explanation of the need for independence and the importance of self-government, or at least government not controlled by the British. It's a detailed explanation of how British rule is unfair and implicitly what would constitute just rule. Indeed, in the text of the Declaration of Independence, after a general statement of the issue, the document expressly notes the facts or proof it considers relevant to the cause, and then goes on to list 27 specific grievances. I'm not going to read them all, but I just sort of note some of the language. They go, before they start listing them, they go, to prove this, let facts be submitted to a candid world. And then I'm going to pick just a few of them. One is, he has dissolved representative houses repeatedly for opposing with manly firmness his invasion on the rights of the people. He has refused for a long time after such dissolution to cause others to be elected, whereby the legislative powers incapable of annihilation have returned to the people at large for their exercise, the state remaining in the meantime exposed to all the dangers of invasion from without and convulsions within. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures. He has forbidden his governors to pass laws of immediate and pressing importance unless suspended in their operation till his assent should be attained, and when so suspended, he has utterly neglected to attend to them. He's affected to render the military independent of and superior to the civil power. He's obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. He has made judges dependent on his will alone for the issue of their officers and the amount and payment of their salaries, for quartering large bodies of armed troops among us, for transporting us beyond seas to be tried for pretended offenses, for depriving us in many cases of the benefits of trial by jury. The litany reinforces the notion that America in general, the American legal system in particular, is not simply intended to be an idea, but a place where these ideas and the ideals underlying them are put into practice. In other words, that these ideals are real and actually transform the lives of those who live in the country. And significantly, the U.S. Constitution at the time of its original adoption, and through the addition of the Bill of Rights, its first 10 amendments, further reflected this commitment to putting into words or providing proof that what we mean is what we intend to do. And indeed, in many ways, the U.S. Constitution is proof of an intent to address the litanies of issues raised in the Declaration of Independence. And taking, for example, some of them I ticked off. The one he has dissolved Representative Houses repeatedly for opposing with manly firmness his invasions on the rights of the people. You look at the United States Constitution, and you see Article 1, Section 1 and 2, quote, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And so that there was this response to this need, these specific grievances then manifest themselves as specific language. You talk about for quartering large bodies of armed troops among us. Of course, that's the Third Amendment. The judicial power warrant, which is obviously near and dear to my heart. He talks about the Article 3, Section 1, about establishing the courts and allowing they shall hold their office during good behavior and shall at times receive for their services a compensation which shall not be diminished during their continuance in office. So this commitment to making ideals real or providing proof that they will be real reflects a relentlessness to ensuring that the rule of law in this country is not just stated as theory, but manifested as fact. And yet, while the Constitution dealt with some of it, while expressing the fears, there were obviously issues that remained. The text permitted Africans to be enslaved, and as made clear both by the text of the Constitution and at the time of the founding and subsequent decisions, the pronouncement of we the people did not secure the blessings of liberties to enslave Africans, Native Americans, and women. And while the expression in the law may have been proof of how legal issues on such matters as slavery needed to be resolved without further amendment of the Constitution as written and as adopted at the outset of the nation was not enough to keep us together as a nation. The dissonance between professed notions of freedom and equality and the unmistakable inequality in American life reflected in the institution of slavery threatened and ultimately undermined the rule of law. We could not stay together as one nation without having to undergo what became the Civil War. Put another way, the relentless nature of the American people meant that theories of freedom of equality are not enough. There has to be real and convincing proof of freedom and equality too. So we endured a civil war, and after the Civil War began to reframe our notion of freedom and equality through the adoption of the Reconstruction Amendments, the 13th, 14th, the 15th Amendments, and then later the 19th Amendment. And then there are those who argue that the 16th and 17th Amendments about empowering Congress to levy an income tax and direct election of members of Senate was another way of furthering freedom and equality. But that's a more nuanced argument and less than I want to deal with tonight. But this relentlessness, however, could not simply be satisfied by words in the Constitution. Although they're very, very powerful, the expanded notion of freedom and equality had to and has to still remain real in the lives of Americans. And you had a gap that persisted and arguably still persists between the belief of freedom and equality as expressed in the law and the proof of freedom and equality as reflected in people's lives. Simply put, as but one example, the permissibility of segregation between Plessy and Brown undermined the nation's professed belief in and reality of the guarantee of equal protection. It is also why the road from Plessy and Brown was paved not just with legal theory, but a carefully orchestrated legal campaign built on proof. Proof that the doctrine of separate but equal did not ensure equality, but instead enshrined the nation further in racial inequality. In the higher education cases aimed at desegregating graduate schools, primarily law schools, such as the University of Maryland Law School, the University of Missouri Law School, and the University of Oklahoma Law School, and the University of Texas Law School, there was not just discussion of racial inequality, but evidence concerning libraries, faculties, classrooms, and other facilities, as well as social science evidence from sociologists, psychologists, psychiatrists, educators, and other expert witnesses. Similarly, just as the work of Charles Hamilton Houston, Thurgood Marshall, Robert Carter, Jack Greenberg, Constance Baker Moutler, and countless others did the legal work to undermine Plessy, Ruth Bader Ginsburg, and countless others work to address the issue of gender inequality. they too focused on proof to do so. The same can be said of legal efforts to create legal protection for same-sex marriage and broader rights with respect to sexual orientation, or even on the road to Roe, or even on the road from Roe to Dobbs. The struggle for freedom and equality, however one characterizes it, still challenges the ability of people to believe in and follow the rule of law. It thus is no coincidence that the response to a seeming lack of freedom or equality has been to test the rule of law. That is what we began to see with great effect in the mid-1950s, where the power of protest challenged the rule of law. When you go back to the Montgomery bus boycott, you had citizens making a decision not to do something they didn't have to do, ride a bus, but they did so to provide further proof that segregation was wrong, and not just in the nation's public schools. There was not a serious issue of civil disobedience, although there were issues about whether some of the private car services developed to get people around violated some laws. But there is the issue of civil disobedience as reflected in marches in public streets, or the decision to disobey orders to disperse as a means of attracting attention to perceived inequalities. And of course, and as a judge, I would be remiss if I did not note this, the fact that perceived inequalities prompted civil disobedience does not and cannot mean that the law can and should not be obeyed. Those who are true to those principles know that they cannot use the perceived righteousness of the cause to engage in violence or even avoid appropriate criminal sanction for violating the law. As Dr. King said long ago, quote, "Violence as a strategy for social change in America is non-existent. All the sound and fury seems but the posturing of cowards whose bold talk produces no action and signifies nothing," end quote. Moreover, and even in engaging in acts of civil disobedience, he argued in his famous letter from a Birmingham jail, quote, "In no sense do I advocate evading or defying the law as the rabid segregationists would do. This would lead to anarchy. One who breaks an unjust law must do it openly, lovingly, and with a willingness to accept the penalty. I submit that an individual who breaks a law that conscience tells him is unjust and willingly accepts the penalty by staying in jail to arouse the conscience of the community over its injustice is in reality expressing the various highest respect for law." In any event, my overall point is not to emphasize or glorify civil disobedience or disrespect for the law as a means for moving society forward, but instead to underscore that whether the law works as intended, proof of justice or a just society is essential to preserving the rule of law. Somewhat paradoxically, or perhaps not, when you really think about it, people believe in the rule of law when there is proof that this belief will bear fruit. If they do not believe it, they act differently. And the preservation of the rule of law is not contingent on everybody always following the law. Instead, it is preserved when nearly everyone understands there is a reason to follow the law and believes that their lives will be better off if they do. To this point, the numerous protests and outcries for change following the death of George Floyd in 2020 are a great example. The videotape of that scene on a Minneapolis street challenged the notion of effective law enforcement, at least in that one instance. The actions were hard to square with the public's expectation of fair treatment of citizens by law enforcement. The incident threatened the rule of law by undermining confidence in law enforcement by even those who were inclined to accept the account of law enforcement of how an incident like that happened normally. And while there were those who might cynically suggest that their accounts of racially disparate treatment by law enforcement should have been taken at face value before the video, in my view, a more salient point is this: the more evidence you have, the more likely you are to change minds, and that rather simply relying on beliefs or accounts that support one's belief, let's figure out ways to increase the proof available and push people to keep an open mind until all of the proof has been developed. Because of the years since the death of George Floyd has shown, just as there is proof that some law enforcement officials might have failed to live up to their oaths, there also will be proof of law enforcement officials living up to their oaths. In other words, civil disobedience to highlight perceived injustices are effective and perhaps only worthwhile to the extent that they actually highlight demonstrable issues, provide proof, grounded in facts and a sensible strategy for change. To use another example of Dr. King's wisdom from many decades ago, showing actually how prescient he really was, here's what Dr. King said about protest, even about protest, about alleged misconduct. Quote, when marchers are carefully organized around well-defined issues, they represent the power which Victor Hugo phrased as the most powerful force in the world, an idea whose time has come. Marching feet announce that time has come for a given idea. When the idea is a sound one, the cause a just one, and the demonstration a righteous one, change will be forthcoming. But if any of those conditions are not present, the power for change is missing also. 1,000 people demonstrating for the right to use heroin would have little effect. By the same token, a group of 10,000 marching in anger against a police station and cussing out the chief of police will do very little to bring respect, dignity, and unbiased law enforcement. Such a demonstration would only produce fear and bring out an addition of forces to the station and more oppressive methods by the police. Dr. King's point has even greater force when we place in context the attacks on the U.S. Capitol on January 6, 2021. Those who participated may in some part have been so dissatisfied with the American political process that rather than accept its results, they decided to use brute force to change them. But there's been nothing produced so far to suggest that their actions had any basis in provable facts, i.e. that there was any evidence, significant or otherwise, to suggest that the 2020 presidential elections was so riddled with fraud that the wrong person was declared the winner or had been sworn into office on January 20th of 2021. And significantly for purpose of this talk, is there any more potent symbol of the significance of proof to the preservation of the rule of law? It is in the response by the overwhelming majority of Americans to this act, revulsion, and the need to accept facts or proof as a means for deciding who wins the election or how the transfer of power in this country should happen. While America has been and always will be provide a safe haven to hold any and every belief, when we decide important legal questions, every legal question that has to be resolved is important to someone in the case. The beliefs are not enough. So our concern for having proof that the rule of law works extends beyond the lawless. There are those who are on the brink who, rather than cry out, they express themselves, like this character in Jesmond Ward's book, Salvage the Bones. Quote, and then I get up because it is the only thing I can do. I step out of the ditch and brush the ants off because it's the only thing I can do. I follow Randall around the house because it's the only thing I can do. If this is strength, if this is weakness, if this is what I do, I hiccup, but tears still run down my face. After Mama died, Daddy said, what are you crying for? Stop crying. Crying ain't going to change anything. We never stopped crying. We just did it quieter. We hid it. I learned how to cry so that almost as tears leaked out of my eyes, so that I swallowed the hot, salty water of them and felt them running down my throat. That was the only thing we could do. I swallow and squint through the tears, and I run. To this third and last point, proof is the most essential element to the rule of law because people need to have proof to believe in the rule of law. Now, we know that not everyone will accept the type of proof the legal system demands, but we do need to get everyone focused on accepting and acting as if proof matters. Beliefs alone, however noble they may be or well thought out they are, will not keep us together. In my view, this is a misguided endeavor. We are a diverse nation, always have been, and we are getting more and more diverse every day. And within this diverse nation are people of all kinds of beliefs and all kinds of things. As a result, it will be hard to survive as a nation simply by exalting a specific set of beliefs where there's a legal or judicial philosophy to exalt it above and over all the others. That is a system where only people who only believe very specific things can thrive, much less survive. In other words, there will not be a place for everyone, just those who hold or are willing to convert and hold certain beliefs. You can do that in a religion, you can do that in a political party, you can do it in a social organization, you can do that with your neighbors and maybe within your family, but we should think carefully about whether we should do that with and to the American legal system. And to be clear, while I'm not a theologian or a political science, I suspect, but don't have proof yet, that proof matters in sustaining one's faith or one's political beliefs. Only the most fervent can go day in and day out believing in something without seeing some tangible benefit in one's life. Instead, for most believers of faith, they have seen real change and real support in their lives, whether it is commemorating a special moment or helping them survive a tragic event. And most people who participate in the political process have seen some demonstrable change in their lives for the better, even if it was not everything they wanted. There were things that brought them back to the political process time and time again. So in the law, instead of uniting around specific beliefs, let us unite around a common belief in proof. that no idea is off the table and where any idea that remains on it is one proven to work. With that kind of unity, one in a common belief in the primacy and essentialness of proof, we can fight over what should be proof. We can struggle over whether a specific type of proof is of sufficient quality or available enough in sufficient quantity. Now, that's a struggle worth having. Indeed, that is the struggle that is going on in my courtroom and courtrooms around the country day in and day out. After all, just like hospitals are not there to heal the well, courts are not places to come if you could resolve the problems otherwise. Instead, there are places with a clear structure for how to resolve the disagreements that people have and that perhaps can only be resolved in a courtroom. And so, far away from the momentous events I noted at the outset, in my courtroom and courtrooms around the country, in cases both known and unheard of, justice is quietly carried out day in and day out. Where I work and where many of the trial judges work, we have seen and overseen the administration of justice, and bit by bit, at least from my view, there lies in the hope in sustaining a robust belief in the rule of law, and the currency of that realm is proof. Because during the same period that I've presided over, I guess about the same time period, the last 3 years, I've presided over about 20 trials, nearly all of them jury trials, and from each case and from many others I've presided over while on the bench, I've come away not discouraged about the American justice system, but encouraged that this emphasis on proof through trials in America, jury trials specifically, provide a path forward from a nation reeling from the effects that the dual crises in public health and a public confidence in the rule of law have spawned. During the same time period where people lament that the American public cannot unite over anything, time and time I've seen people from different walks of life, races, genders, economic statuses, and other differences come together and unanimously render verdicts. In jury trials, it's not a majority rule proposition. Everyone on the jury has to agree, or there is no true or just verdict. Maybe they're able to come together because in a court of law, the nonsense is kept out and what only truly matters and what can be truly supported comes in. But it is a sign that people can come together around proof and a common goal, rendering a verdict and not simply be guided by their own specific beliefs. It is this proof, and not just any kind of proof, but proof of a certain quality and of a sufficient quantity that has and will sustain us as a nation, proof that people do not just believe in the rule of law, but have been and are helping to sustain it. Thank you very much. You want me to stay up here to answer questions? Sure. Okay.
So we'll have some question and answers now, or we'll have questions and answers from Judge Bolden. And so while you're thinking about your question, I thought I might, first of all, you've convinced me completely, but I had a question about the criminal justice system and the extent to which proof is central to the rule of law in criminal law, in particular with respect to plea bargains, and where we might see pleas to events that may not have happened, or so I thought maybe you could speak a bit to that, because it seems like it might be, maybe you've seen an exception. How does proof play out there?
Well, I think, well, I'll say that. The issue of plea bargain in the context of the criminal justice is, it often causes a lot of consternation. I will say that, one of the things that I certainly am comforted in the context of that, because I don't believe that I'm required to accept a plea if I don't think that there's sufficient proof that the person actually did the thing that they've come here to say I did, and plead guilty. Indeed, and I'm glad to see my former chief, Judge Underhill here, who when I started on the bench, I was able to use scripts from him. And one of the things is when you get near the end of, asking the defendant questions about what the person did, if you don't feel satisfied that the person actually did it, or that what the government says is proof may not match up, my view is you're not supposed to accept the guilty plea. And so there's an inquiry that you're going through. So and my hope and faith is that all of my colleagues around the country and are doing the same thing. I'm not saying it happens often, but I've had a couple of occasions where I said, okay, I think we need to take a break. I'm not sure you're ready. I had a defendant who was we were actually getting very close to trial, and we were going through the process of engaging in a plea bargain. And there's a part where I ask him, if he's actually read the plea agreement and read it carefully. I asked him, have you read the plea agreement carefully? He says, carefully? And I was like, okay, let's take a break. So I think the answer to that is, I believe in certainly in the system, there is the role that judges are to play to make sure that they are convinced that the person who is actually pleading guilty actually is guilty.
Okay, I have a microphone if anyone wants to ask a question. Yes.
Thank you, Judge Bolden, for your talk today. But jumping off that last point, how do you square that with Alford pleas?
Well, we don't do that. We don't do that in the federal system. That's Judge Bright. I think that's your. I can't comment on that. Which to be clear, because we've got the esteemed members of the state judiciary here. I'm not suggesting it's a wrong thing, but I'm comforted by the fact that I got to be comfortable that someone's here to plead guilty to the crime, and that's not just I'm going to take the punishment and plead guilty. But it's an excellent question.
Okay.
Hi, Judge. Thanks for that. It was sublime. I'm wondering about it. So I'm broadly on board with what you're saying in terms of kind of Enlightenment rationality and reason giving that bottoms out as proof as a way to solve maybe our only hope for really kind of solving or managing the problems of pluralism that attend to any kind of complex social order that we want to live in. I guess here's my hang up, and I'm curious to hear you reflect on it. It seems to me that in addition to the set of commitments you're outlining here, that we, and in some sense every social order that we might want to be part of, would be defined also by certain kinds of normative questions that we want to take off the table, that we actually don't want to subject to the normal processes of public deliberation, including but not limited to proof in the way you're using the concept. So like, I'm thinking, for example, in our political tradition, I'm kind of proud of the fact that in the United States of America, we don't sort of take like neo-Nazism seriously. We have a First Amendment that I think kind of allows for that to be expressible in certain domains, and we should be proud of that too. But the reason we have that and should be proud of it, the kind of First Amendment protections in that regime, is precisely because we don't want to and should not take it seriously as an aspect of our actual kind of public life. That in fact, I'm persuaded by the arguments that Ronald Dworkin and others have made over time that like, that's exactly, we let people sort of express awful views on their own time, so to speak, and we would frown at sort of a censorious model of trying to suppress those views entirely, but that's precisely what legitimizes kind of our sense of self as a civic culture that doesn't actually take those views seriously. And so I guess I'm wondering, are there questions in your view that kind of should be taken off the table? If somebody came to the public sphere and said, look, I think we should bring whatever it is. I think we should, retrench the franchise for women. I think we should bring back chattel slavery. I think we should, any of these monumental marks of historical progress we've made, right? And they said, listen, hear me out. You might not ultimately agree with me, but the reason you want to agree with me is because, the Bolden model of proof, right? We'll have an argument, and my proof won't be satisfying beyond a preponderance. I think we would just say like, no. Or at least that's what I would want to say. I'd want to say, I don't want to hear your argument or your proof at all. Well, and I think we ought to kind of be celebrating that too.
I guess I would just sort of distinguish a couple things. I mean, I'm not suggesting that people shouldn't believe what they want to believe, and the people should be free to believe what they want to believe. I guess what I'm suggesting is in that what I think what we are expected to do in the legal arena when people walk in the courtroom door is that we have to let people know it's okay to believe what you believe, but when you come here, this is a place of proof, right? You can believe anything you want to believe, but when you come here, we're going to need evidence that people recognize as evidence that's going to allow a proposition to move forward, not just because you believe it, right? And so I think that's what I think that's where we're really struggling. It's not that people shouldn't be able to believe what they want to believe. It's just that when you come into this, there are certain spheres when you come into that arena, the court, the expectation is what's going to be there. And, part of what I'm sort of reacting to in terms of thinking about in terms of proof is I think that more and more, I see more and more people coming into court thinking that as long as they hold on to some belief that has some magic power in the context of court. And it's like, well, you're welcome to believe what you want, but you come here, there are expectations we have in order to advance your idea legally. And I think that's what I'm really trying to, maybe if push back is maybe a little strong, but that's what I'm really trying to articulate and deal with.
Hi, Victor.
Hello, Chief.
Your thoughtful remarks made me wonder whether you've also given any thought to some of the challenges that modern technology presents to prove deep fake videos, for example, or generative artificial intelligence, that kind of thing.
Well, I think that the general structure of the Federal Rules of Evidence allows us to sort of deal with it, right? Because they really often will fall in the category of some kind of hearsay, or often, and the question is there a sufficient evidentiary foundation to allow some of these things in? And it really does raise the question, is it's like, because there are a lot of people who are, well, I think it's clear that there are people who believe in certain things because they've seen it on the internet. And so the question is, when they bring that into the courtroom, is where we have to sort of recognize, look, we're going to push back, and our expectations, we understand that technology could allow for it, but our expectation of what's going to be evidence is going to be bound by, do we really know where this came from? And do we know what the source, is it really what it purports to be? That whole standard of sufficient indicia of reliability is one, I think, that gives us good reason to really challenge that and increase the expectations. I've actually seen it with attorneys where they sort of think, oh, I've got a newspaper article, and that sort of, which is not even at that same level, but it's still a thing they appreciate that there is a distance between someone saying someone out there and what should actually come into the arena when we're trying to deal with these important legal questions.
Hi, thanks. This was so interesting. I think I'm still thinking about this idea of the courtroom and the way that, certain beliefs don't have a place there, and we need to give over to proof. And then we have these mechanisms which may or may not be up to the job of getting the right kind of proof in there. But I wonder, it seems to me that we're always going to be constrained in some sense by fact finders' lived experience, which is different from belief, but related, I think. And so I wonder how lived experience fits into this concept of proof, and can we ever, sometimes we may have constraints in lived experience that are not allowing us to see the truth.
Yeah.
For lack of a better word. And, can proof save us from that? If so, how?
Well, that is that proof's going to save us. It's that we have to sort of decide and be committed to what we're going to, certain standards of what's going to help decide things. And I think part of the thing what you're alluding to is this question of people who may end up serving in a jury having certain issues or challenges. And I think what that really means in the general context, there are specific people who just, for whatever, certain beliefs, they're going to really struggle with the system as a whole. There might be people who may not be right for a certain case because of a particular experience in the context of their life. Like I was talking about people who've been, had people close to them, had someone deal with a drug overdose, and so that affects their ability to sort of be a fair and impartial person to be deciding a case involving that. And so what we're really, I think the question is are we able to make sure that some specific issue that someone that has some real personal connection to someone doesn't cloud their ability to be free and look at the evidence fairly. And so we're really trying to push people to say, look, really think about what's preventing you from be able to engage in an honest discussion, and then engage in, with others. I mean, like I said, the more I see it, the more I'm really amazed that, we bring these people, they didn't know each other, and we put them in, we put them together, and, they're able to come unanimously. I mean, it doesn't happen every time, but it happens a lot more. And people who were reluctant to be in the process, they sometimes find themselves enjoying it. And it strikes me as, on the same time we worry about the country being divided and can't get along, we've got people who didn't know each other before, and they making a monumental decision, all of them the same one. It's like I said, it's just like there's no opting out or we don't have a verdict. It's like, I'm not with you. You 11, you go ahead. We don't end up with a verdict. But the fact that all 12 of them can agree, I think that there's some power in that, and I do think that some of it has to do with, obviously it's about it's important in terms of the selection process to make sure people who are actually willing to actually engage in the process legitimately, that makes a difference. And also, it also matters that we're careful about what we expect from them. And we tell them what we expect for them in terms of holding to a standard that we want them to be thinking about proof, not thinking about what they think is proof. So I think that there are all of those elements that go into it, and it's really just a question of really affirming and affirming and affirming that, because I think there's value in it. Thanks for your question.
Do I have a student? Yes.
Thank you for being here with us. I will get to my question eventually. So, some things that stood out as you were speaking were public perception, public opinion, and civics. Our collective buy-in, our belief in this system. Your distinguished clerk and UConn alum Mallory shared that she'd be, teaching civics to 5th graders sometime in the future. And I find that very encouraging. But we do need this collective buy-in. And I've heard, in some conversations, even some classes, constitutional law, administrative law, criminal procedure, and EDGE come out in students' voices that signals a bit of a disdain for the Supreme Court. And maybe not the institution, maybe sometimes just the justices themselves. And that's not to even touch on what might be going on just beyond our halls here, right? You might have people on the street who say, you've seen the proof, of how Roe impacted women's lives. You've seen the proof of, affirmative action, success stories, doors opened and whatnot. And this court, because a fish rots from the head, the Supreme Court appeared to maybe turn its back on those, or some of the justices did. So in light of all of this, you have public opinion, you have the courts trying to persist in this promise of following, what the proof says. What fills you with optimism in light of that? Because you seem optimistic from how, where you landed in your remarks. So what makes you optimistic in light of that?
I mean, I said it. I mean, it makes me optimistic because when I go to court every day and I have trials and people are, people come and are willing to engage on these issues and come together and decide things. I mean, that's the proof for me is I'm seeing it. And, and in the past couple of years, I've been, trying a lot of cases and you sort of like, there's something going on there. The people are able to do this. However, whatever's going on, they're able to come in there and do it and have a different experience. Okay. Yes. Oh, there's one in the back and the one there.
It's 6:45.
Oh, it's 6:45. All right, so we would.
And I'm on that optimistic note. Thank you for this wonderful lecture. There's still 15 minutes of reception left to go.
So I'm done.
I thank you.
Thank you all.